municipality that wants to make a public submission?
Good morning, sir. My name is Annette Potgieter. I'm from the Mossel Bay Municipality Corporate Services. I may be replaced by someone from the Legal Services Department shortly, but until then, I will be standing in. Thank you, Chairperson.
And then, yes, we don't see anyone at this stage from the Premier's Department. Okay, do they have their hand up online? You can just introduce yourself as well.
Good morning, Chairperson and members. My apologies, but I had a bit of an issue with my computer earlier. But it's Astrid Miller from Legal Services at the Western Cape Government. My understanding is that the Western Cape Government will not be making an oral submission today, but the Western Cape Government have submitted written inputs, and it would be appreciated if those inputs could be considered by the committee as part of the public participation process.
100%. Then are there anyone else that wants to make a submission? I don't see any hands online. Colleagues, then we will proceed with the presentation from the Public Service Commission representatives here. So over to yourselves.
Thank you very much.
Sorry, just oversight from my side. Colleagues, just a reminder that the rules of the House in terms of both the online conduct as well as conduct within the meeting, of course, applies. Goes without saying, but I think it's important just to state it for the record as well. So you can proceed.
Thank you very much, Chairperson. Chairperson, the presentation on behalf of the Public Service Commission will be done by Advocate Makinde. She's our Head of Legal Services. But before she starts, perhaps just a few opening remarks from my side. First of all, we want to thank the committee for setting aside time for this very important engagement on a very important piece of legislation for the Public Service Commission. I also need to tender a few apologies for the record. Our chairperson, Professor Somadoda Fakeni, is unfortunately out of the country attending a Public Service Commission engagement in Africa. And our DG, Advocate Dinky Dube, is also indisposed today. They would have joined us today and they've asked me to tender their apologies. Chairperson, the Public Service Commission is of the view that this bill is an important entrance for us to safeguard a few fundamental issues. Two primary objectives that the bill seeks to address. The first one being the independence of the Public Service Commission. Members will note that in terms of the current legislation, the Commission, although a constitutional body, is not truly independent. We still consider to be within the framework of the national government architecture. So we are managed, comprised, and structured as a national government department. And that has a number of challenges, especially if one considers the nature of the commission, its constitutional duty, and the functions that it performs. We are monitoring an oversight body over government. And to have us within the architecture of national government is deeply problematic for a number of reasons. Chair, you can understand that we oversee all departments, including departments such as communication, public works and infrastructure, but yet we are also reliant on those departments for particular services, and that causes unique challenges for us as a constitutional authority. The Constitutional Court has been very clear with regards to the structure and independence of constitutional bodies, and has ruled in one matter that a constitutional entity must be seen to be truly independent. So it cannot be structured within the national government architecture. And as Advocate Makinde will take you through the presentation, she will give you some insight into the process that we followed in doing a business case for the bill. And one of the primary objectives was to ensure that we become a truly independent constitutional body outside of government. So that is one of the core objectives that this bill seeks to achieve. The other one, Chair, which can be viewed as controversial, we've seen and heard the submissions in the National Assembly at the Portfolio Committee for Public Service and Administration, where the second objective, which is to extend the mandate of the Public Service Commission to local authority and state-owned entities. There are different schools of thought on that, and I'm well aware that the Western Cape Government Department of the Premier has submitted, both during the Portfolio Committee's within the National Assembly, they've submitted submissions with regards to those particular issues. Mossel Bay Municipality, during the process, I think we only received an objection, but not an objection which went into the specific issues that the municipality wished to raise. So we will be keenly listening to those submissions from the Mossel Bay Municipality, and thank you for them for joining us today, Chair. So, Chair, those are the two primary objectives that the bill seeks to achieve. There are other issues with regards to the manner in which commissioners are appointed. That's an important issue because it speaks to the professionalization. As you will see in the bill, there are specific provisions which now contain a criteria with which a potential commissioner must comply, both in terms of experience as well as educational qualifications. And those are important provisions that the bill seeks to address, Chairperson. Chair, you will also see that the bill, although not specifically mentioning the issue of professionalization of the public service, we are of the view that this bill will go some way in ensuring that the Public Service Commission can fulfill its mandate as crafted in Cabinet's professionalization framework. So this bill will ensure that the Public Service Commission can fully implement its mandate with regards to professionalization of the public administration. And when I say public administration, it's not ring-fenced to the public service as we know it, which is national and provincial governments, but public administration in the sense that it applies to national, provincial, municipalities, as well as state-owned entities. And the Commission has a distinct role that is given to it in that sphere. So, Chair, by way of introductory comments, I will leave it at that and hand over to Advocate Makinde, and she can take you through the presentation. As you can see on the screen. There's 8 areas within the presentation that we will cover. Thank you, Chairperson.
Please proceed.
So, good morning once more. Our presentation is up on the screen. The presentation outline shows that we would just like to introduce the PSC leadership, because the leadership is determined in terms of the Constitution, which creates 14 commissioners. We'll talk briefly about the mandate of the Public Service Commission, some of the products that and the output that we are busy working with at the moment. We'll talk about the objective of the PSC bill, the institutional practice review, which led to the drafting of the business case, which informs the bill, the priority areas addressed in the PSC Bill 2023. We'll talk briefly about the parameters in local government and the PSC mandate. We'll talk briefly also about the progress report on the PSC bill and the way forward. In terms of our leadership, we have 14 commissioners. On top there, you have Professor Fiskeni, who is our chairperson. And next to him is Commissioner, the deputy chairperson. I'm sorry, just give me a minute. My laptop just went up here, but it's fine. I'm going to proceed. Okay, next to him is the deputy chairperson. And then we have 3 other commissioners who are based in the national office right there. Below you have the 8 commissioners. We have 1 vacancy. Commissioner Steele is right in the middle there on the left, who is a provincial commissioner for the PSC in the Western Cape. We have 1 commissioner per province. Can we move on? The mandate of the PSC, as you will see on the screen there, it talks about the PSC oversees the public administration within public service as per Chapter 10 of the Constitution and in accordance with the National Assembly. And it's accountable to the National Assembly. Is it possible to make this a presentation? Make it big? Is that a presentation slide? Okay. So, just give me a minute just to get there.
Yeah, the older we get, the Colleagues, we can see from distance.
Just give me a minute, please. Just want to see if I can get a better one I could use. Yeah. Okay, that's fine. Okay, the mandate of the Public Service Commission, as you will see there right in the middle, you have the founding values. Those founding values are based on the Chapter 1 and Chapter 2, or Section 1 and Section 2 of the Constitution, which talks about the human dignity, equality, human rights, and all of that. Now, when you see this the brown circles, those are the constitutional values that we are promoting in terms of Section 195 of the Constitution, and we call them the CVPs. In addition to that, we also conduct investigations, monitoring, and evaluation. We propose measures, we give directions and advice that are in the interest of maintenance of an effective and efficient public administration over the public service. PSC products and output. Okay. Some of the products that we market is that we do research in administration practices, human resource management, ethics, labor relations tool, and on-service delivery matters. We also do report fact sheets and guides. We do investigation on grievances and complaints. Sometimes we do citizens forum. The citizens forum are like in Bezos sort of, where we bring government departments and people who are having some challenges together so that they're able to speak directly to them and see how they resolve some of the problems. We conduct inspections in local, either to the site or even on documents. We sometimes do CVP promotions, which is the constitutional values and advocacy. We're looking at ethics. We look at the code of conduct, policy development, decision-making, and in addition, professionalization of the public service and public administration. We also facilitate assessment of performance agreements of HODs in the presidency and office of the premier. Going forward, we might be doing that also in the local government or local municipalities. Now, the objectives of the PSA bill. The bill was introduced in Parliament in the 6th administration, and it continued with the 7th administration, basically to achieve the objective that Commissioner Steele has already mentioned, which is to repeal the Public Service Commission Act of 1997. We have a current Public Service Commission Act of 1997. That act is talking about implementation of the PSA mandate in the public service. And we realize that that act is not aligned fully to the Constitution. And the mandate of the PSC is across public service and across public administration. So we have to repeal that act to now enact this new bill, which is now the Public Service Commission Bill of 2023. And then to establish the PSC Secretariat. The PSC Secretariat is seen as a national government department at the moment. It is called Office of the Public Service Commission, established in terms of the Public Service Act. So the PSC Secretariat will be established in terms of the Public Service Commission Act and not the Public Service Act, because we are not supposed to be part of the public service. We are supposed to be an independent constitutional institution. And this is in line with Chapter 13 of the National Development Plan as well. Implementation of the application of PSC mandates to municipalities and public entities. This is to promote cohesion in governance while recognizing the nature and function of the different spheres of government. Furthermore, it is important to mention that Parliament took a resolution on the 15th of November 2011 that the PSC must report on the implementation of the Section 195 of the Constitution by the administration of government, organs of state, and public enterprise. This resolution actually was when we then started looking at our bill, and that was already in 2011. If you look at the Constitution, why the Parliament took that resolution, you will see that Chapter 10 talks about public administration. The heading there is public administration. It starts with the basic values and principles governing public administration. Those values, they are applicable across, they apply to administration in every sphere of government, organs of state, and public enterprise. The National Assembly look at the fact that there is a single Public Service Commission for the Republic, and the Commission is empowered to look at those values and principles set out in Section 195 and to promote them, and also to report on those values and the implementation. They went further to look at the Commission is independent and must be impartial and must exercise its powers and perform its functions without fear, favor, or prejudice, in the interest of the maintenance of effective and efficient public administration and a high standard of professional ethics in the public service, the Commission must be regulated by national legislation. So this national legislation is what we are dealing with that must further expatiate on all these mandates that is already there in the Constitution. Now, the PSC is also to be recognized as a constitutional institution in terms of Schedule 1 of the Public Finance Management Act, which is what should have already happened. And this, we believe, will help in the improvement of public service and public administration as part of building a capable, ethical, and developmental state. In strengthening the independence of the Public Service Commission, we also look at the process of appointment of commissioners. We believe that the commissioners are, the commission is a constitutional institution, and those commissioners, their determination of remuneration should be in line with Section 2195 of the Constitution. So this is one of the additions that the bill is making so that they are aligned to other constitutional institutions as it should have been. The PSC is then repositioning itself so that it has a much more better role in improving effective and innovative developmental, ethical, and professional public service and public administration. The PSC then undertook, I'm on slide 9 now, the PSC then undertook an institutional practice review to see how it can fully implement its constitutional mandate. This institutional practice review led us to develop what we call a business case for the bill. And as in developing that business case, we realized some of these deficiencies that we're now trying to fix with the bill. So we did this benchmark exercise, which then talks about we need to strengthen the OPSC independence, that is creating that secretariat of the PSC to support the PSC, so that there is no conflict of interest in having a national department supporting an independent constitutional institution. Service delivery and capacity constraints within the PSC itself was also looked at so that we are able to implement the full mandate across the board. We look at how to improve the PSC enforcement mechanism, because there has always been thought about some of our recommendations, sometimes they are ignored, not being implemented, and they need to give the PSC the tools to become more effective. So the business case looks at those models of how to improve the PSC enforcement mechanism. It also looks at the PSC power to issue recommendations vis-a-vis the power to issue directions, which the bill tries to differentiate between the two and how those processes should be addressed, especially looking at recent case laws. The use of alternative dispute resolution mechanism in managing grievances and complaints, which we already do, but we hope to enhance the use of that method so that things could be done faster. And then we look at the process of appointment and removal of PSC commissioners, the remuneration of the commissioners, implementation of the PSC mandate in local government and public entities. In doing our comparative analysis, we look at the PSC's South African Regional Public Service Commissions. We also look at the Singapore Public Service, the Public and Discipline Force Service, PSC of Mauritius, PSC of Uganda, PSC of Kenya, and all the others that are listed there. What we then found is that the PSC is actually a constitutional institution created in terms of the Constitution, and therefore we need to replace our Public Service Commission Act of 1997, which is one of the things that this bill is dealing with, to abolish and to replace it with a new act. And now the PSC explored other models outside the public service and realized that it has to be a constitutional institution to establish its own separate secretariat, because all the other, for example, the Chapter 9 constitutional institutions, they all have their own independent secretariat. It's actually the PSC only that is still remaining with the national government department supporting it. Benchmark studies with Chapter 9 institutions, like I've said, indicated that. And then we look at the case law, in this case of Langebad Municipality, where the court have said that, when you are talking about the independence of the constitutional body, yes, it is guaranteed by the Constitution, but that independence must not just be seen as guaranteed, it must be actual in the way it is formed and the way it is structured and funded. So it needs to be actual independence. So looking at that, we then said, let's look at the other Chapter 9 institutions. You can see they all have their independent secretariat, even with those 3 that are listed there. Now, the content of the bill itself. The bill starts with a preamble, which set out the purpose of the bill, as we have been discussing, which is to regulate the Public Service Commission in accordance with the provision of Section 196 of the Constitution. This bill is not introducing anything new. It's simply giving effect, because there must be a national legislation to give effect to those full mandates to deal with the appointment. That's what the Constitution says. And so this bill is just doing that work that is required from the Constitution. The Commission must be regulated by national legislation. And then this bill, which is a national legislation, is regulating the PSC in accordance with Section 196 of the Constitution. It's also to regulate the procedure for the appointment of commissioners of the Public Service Commission, because the Constitution says there must be a national legislation to further regulate that. Also provide for the establishment of the Secretariat of the Commission to support the work of the Commission, and to repeal the Public Service Commission Act of 1997 and to provide for matters connected therewith. So that is the purpose of the bill. Now, the bill is divided into different parts. Part A deals with definition and application of the Act. Clause 1 deals with definitions. Most of our definitions in the Act, in the bill, are aligned to some of the existing legislations that are already there. And then we then talk about the application of the Act, where we then say this bill, the PSC Bill 2020, applies in relation to administration of the public service and public administration. It is important to know that Public Service Commission deals with administration mostly. Administration matters. We try to avoid the political matters because we don't deal with political office bearers. Hence, we said administration in the public service and public administration. That's the application of the Act. And then the public service and public administration are defined in the definition. Now, the Public Service Commission, that is Part B of the bill, is talking about the constitution of the commission itself, which talks about the 14 commissioners that we have displayed their pictures up, and the 5 commissioners that are, the 5 commissioners that are appointed at national, and the 9 commissioners, 1 for each province, which is just aligned to the Constitution. Clause 4 then deals with appointment of commissioners. If you look at the Constitution, it talks about a commissioner must be a South African who is skilled in public administration and other relevant fields, who is also a fit and proper person. Now, just to give effect to that, skills, a South African fit and proper person, we just expatiated a little bit more because they said there must be a national legislation to give more direction on that. So this national legislation is simply saying the commissioners, as we are trying to professionalize the public service and public administration, must also be professionalized. So they themselves should at least have an NQF level 8 qualification in some of these fields that are recommended in line with the type of skills that the Constitution has identified, and also 8 years management experience before they can apply. And then Clause 5 went further to talk about the disqualification from appointment as commissioner. It looks at people who have been found wanting. If you have been found or dismissed for misconduct or anything of dishonesty or things like that, you will not be qualified to apply to be a commissioner of the PSC. Then it went further to say the PSC must not be politicized. It is an independent constitutional body. Then we said that any member of parliament or any political office bearers or legislature or whatever who wants to apply for a PSC commissioner post must have left that post for at least 2 years cooling off period before they can apply, so that they must know that when they come into the Public Service Commission, they're coming as professionals, not as a politician. So they must not apply while they are still members of the House or something, because they will be applying to themselves in any case, because commissioners are appointed through the legislature or parliamentary process. Now, Clause 6, limitation on performing other work by commissioners. The commissioners are appointed on full-time basis, and they must remain a fit and proper person for that 5 years. If they are fit and proper, their term of office is renewable for a further 5 years. So they don't have to re-advertise those posts after the 5 years. It can be renewed as the Constitution had made provision for that, for as long as the commissioner remains a fit and proper person. That means he has done his work and there is nothing wrong during those first 5 years. Now, if the commissioner wants to resign, he must give at least that 120 days notice to the president so that they are able to start the process of appointment. We don't want delays because one of the things that we used to have is you can have a vacancy for a very long time and it's prejudiced the work of the commission. So we want these things to run smoothly so that there are no delays in appointment processes and having the post filled. Clause 7 deals with the designation of deputy chairperson and the chairperson of the commission. All commissioners are appointed through the same legislative processes, either through parliament or through the provincial legislature. But after appointment, the president will designate one person, one of the commissioners as the chairperson and another as the deputy chairperson. That will be based on the discretion of the president, looking at the quality of the people and their experience and their leadership, and then he will then decide who becomes a chair or a deputy chair. But that is just by designation. Now, if it happens that the chairperson is not around, the deputy chairperson will automatically step in to do the work of the deputy chairperson. What is then added is that should it happen that both of them are not in the office for any reason and they're unable to perform their duty, none of the commissioners can say, I am now the acting chair or I'm acting deputy chair. Another person will have to be designated as an acting chair or acting deputy chairperson by the president for a period of 30 days. And that is just to monitor, to make sure that at least one of them should come back so that the commission is not left without leadership. So 30 days, that 30 days may be renewed if it is necessary. Otherwise, if it is continuous for a long time through the monitoring by the presidency, they can then designate another person, another commissioner as a chair or as the deputy chair as may be necessary. Clause 8. This with the remuneration and condition of appointment of commissioners, which is basically saying that their condition of service should be aligned to the Independent Commission for Remuneration of Public Office Bearers. So as soon as this is done, we will have to make sure that that commission also determine the condition of service and make recommendations to the appropriate bodies as they do with other commissions. Inspections by the commission. Commission conducts inspections, in local inspections of documents, inspection of premises, and all of that. This is an existing power that we have in our current legislation. All we have just said is that this applies to both the public service or public administration. Investigations by the commissions, we already do that, but we are also saying it applies to public service and public administration. Summoning of witnesses is also something that we already do. It is in our existing legislation. But we are now extending that also to public administration. And we are saying that if the summonses are not honored and they are not dealt with appropriately by any administration, which are public servants in both the public service and that will be considered as a misconduct. And there should be some subsequent consequent management and disciplinary action against such an employee. And then it talks about access to reports of the commission. The commission issues reports normally to the executive authority or to the HOD. Some of the affected parties get letters, which is just telling them exactly what has happened and this and that as a feedback from the commission. But we are saying that if you're an affected party or you're the party that is relevant for the purpose of this investigation, you might get the report, but that will be done in line with the Promotion of Access to Information Act. Now, implementation of decisions of the commission. We are saying the relevant executive authority or the HOD to whom a recommendation or direction is issued must implement that. If it is a recommendation, the person has 60 days to come back to the PSC, which is already there in the Public Service Act anyway. But we move that into this bill to say you have 60 days to come back to the PSC to say what you are going to do. What are your action plans? How are you going to implement those recommendations? You cannot receive a report and you keep quiet. You must come back and say, I have received the report. I agree. This is what I'm going to do. I will correct my errors. I will make sure we do this and that. It's because whatever you are doing affects the entire public service, and we want to make sure that that is corrected. Now, if it is a direction that the PSC has issued, those directions are binding on you. And we are saying you must implement those directions because that will be issued in more serious cases. And you will then have to take that report on review if you do not want to implement those directions. And all of that, you must take that decision within 60 days. Independence and impartiality of the PSC. We are saying that the PSC is created as an independent and impartial constitutional body, but we are now extending that to the officials and the commissioners of the PSC itself, that they must also be independent and carry that mandate of the PSC. Should they have any pecuniary interest in any matter that the PSC is dealing with, they must recuse themselves. Anyway, they do that is just to ensure that that is done. That is why we just include it in the act to show the level of professionalization that we want in the PSC. Now, obstruction of the commission. Anyone that obstruct the work of the commission, because the Constitution has said in section 1963, other organs of state through legislative and other measures, they must assist and protect the commission to ensure the independence, impartiality, dignity, and effectiveness of the commission. No person or organ of state may interfere with the functioning of the commission. Therefore, if anybody obstructs the work of the commission, that becomes an offense, and it is done against that section 1963 of the Constitution, and that may attract a civil claim against that person, including that consequent management, and it could also attract a criminal case and a report at the police station for failing to do their constitutional obligation. Now, section Part C, this was Secretariat of the Commission, where we are establishing the commission itself. The commission already has its existing staff. They will move through function shift into the Secretariat, and then the Secretariat will then look at its resources and reestablish to make sure that it has the capacity to deal with the expanded mandates and the full mandate of the PSC. Now, the delegation of commission's powers and functions. Currently, we do have delegations of authority. We have what we call the plenary, which is the highest decision-making body. And we have plenary committees that receive delegations. So those delegations will then continue to be done. We do have charters for each of those committees and mandates or term of reference and things like that. So that will continue. And there could be delegation also to the chief executive officer. In terms of our finances and accountability, we are currently regulated by the Public Finance Management Act. The PSC will continue to be regulated by the Public Finance Management Act, and it will still be audited by the Auditor General because it remains a state institution. Part E deals with general. PSC has a legal personality, and when you want to sue, you sue the PSC because there is a single Public Service Commission for the Republic. The commissioners work as a single body, and you have to then know that the decision is made by one commissioner. It is the decision of the entire commission because the way we make our decisions, the whole commission takes the decisions at the time. And then the rules, we make rules, which is just like what you call regulations in the public service. We have the grievance rules, we have the complaint rules. These are just like regulations that we do in order to give effect to the legislation so that it's easier to implement and to deal with things as we move along. So those rules will continue to be effective and we'll continue to update them. Repeal and amendments of laws. Certain laws have been repealed, such as we have said, the PSA, OPS, the Office of the Public Service Commission, is listed as a national department in the Public Service Act. We are saying that must be removed, and then it will no longer be there. Will now be only established in terms of the Public Service Commission Act itself as a PSC secretariat. We're saying that the commissioner's remuneration must be determined as part of the Commission for Public Office Bearers. We are saying the PSC must be listed in the Schedule 1 of the PFMA and things like that. So those are the things that are there in the repeal and amendment of laws. In terms of the transitional provisions, the bill says that for the first 12 months, the PSC Secretariat will be established, the function shift will happen. We will look at our resourcing and look at our models of performance and all of that of this full mandate. That is what we will do for the first 12 months and also try to get more resources. And then subsequent to that, during that 12 months, the implementation of the mandate to local government and the public entities will be suspended. Doesn't mean that we will not do minor things, because we still do those minor things even now, but it will not be fully active yet. And then we will then have to then take it over. And we hope that within 3 years of the passing of the bill, we will then increase it incrementally as the resources improve. The PSA will also be able to bill for some of its functions where it is necessary in order to improve its ability to do the work, and also to look for resourcing, funding, and all of that so that we are able to work better. And then the short title and commencement, it will be the Public Service Commission Act of the year that it will be then be finalized. Now, local government, where we are simply saying you must note this, Section 151 of the Constitution deals with the status of municipalities that must be established for the whole of the Republic. I think what is important here is that Section 151 talks about municipalities must be established for the whole of the Republic. And again, it went on to then say in Section 1961, there is a single Public Service Commission for the Republic. So the fact that the PSC is meant to work for the Republic and local government is part of the entire Republic, it's clear. And that this public administration values are applicable in every sphere of government, organs of state and public enterprise, and the PSC is responsible to oversee and make sure that those values are carried throughout public administration, because the commission is established in the interest of the maintenance of effective and efficient public administration. And if you look at 197, that clearly says within public service, there is a within public administration, there is a public service. So all of them are synergy and they are together, and the people working in local government are seen as public servants. Within the Republic, there's a public service for the Republic. And the PS is meant for the entire Republic. So I think those are clear. And we will then move on to the need for the human resources. We know that in Chapter 7 of the Constitution, local government spheres consists of those municipalities. And all of these values and the constitutional values are already recognized, even at local government, as applicable to them. And there has to be that oversight over those. What we then say here is just to note that there are quite a number of municipalities. For example, in the Western Cape, I think we have about 30 municipalities and 1 metro, if I'm correct. But it's just to say that there has to be some sort of incremental and progressive implementation across all of this. If we then go on, so we believe that the Bill of Rights is binding upon the executive and all organs of state. There's a duty of them to implement their constitutional mandate quicker and with due diligence. So this will ensure that those assigned the duty of service delivery to local governments, municipality functionaries are held accountable if they fail to perform their constitutional and legislative mandates. We can then move on to the progress report on the PSC bill. The PSC bill has been going on for quite a while. Like we said, it started long around 2011, and we've been working on it since then. Many versions up till the one that you have now that is actually passed by the National Assembly is the 7th version of the bill. Now, the PSC bill was published in the National Gazette on the 9th of June. The notice of the PSC bill was then published in 2 national newspapers for public comment. Written input were received from 16 institutions, and only 3 did not fully support the PSC bill at that time. But most of those 3, we have spoken to them many times in many engagements, and they seem to understand what the bill is all about. The PSC bill was then approved by Cabinet around September 2023 for tabling in Parliament. Because before the bill can be approved by Cabinet, we've been doing a lot of consultation, foresight, so many structures, ministerial structures, and so many entities. We've had many workshops, and then it was then allowed to go to Cabinet. Parliament was approved for tabling in Parliament, and then the bill was then certified by the Chief State Law Advisor as fully compliant with the legislation, because you cannot table a bill even in Cabinet if the Chief State Law Advisor has not certified it as fully compliant with the law and with the Constitution. So the bill has been certified, and it went through the 1st and the 4th reading. The PSC bill was then tabled in Parliament on the 13th October 2023. The Parliament also, through our portfolio committee, published this bill for public comments again. They also held their own public hearing. And during the time for the 6th administration, that was when this bill was published, but they could not finalize it. The 7th administration took over the bill on the 25th of July, 2024, and continued with the bill as a priority bill. So this PSC bill was then presented in the Portfolio Committee of 4th September 2024, where they then did the public hearings between the 29th October 2024 to the 2nd of December 2024. The Portfolio Committee adopted the PSA bill on the 5th of March 2025. Bill was then presented to the National Assembly and it was adopted on the 18th of March 2025. The PSA bill is now before the NCOP, and that is why we are here with you. The bill that we are presenting to you now is the bill as adopted by the National Assembly. The PSA bill was presented to the NCOP on the 13th of March, where all the representatives, the permanent delegates were present, and they are now taking it to their different legislatures. In terms of meeting with the different legislatures and the NCOP, we've been very busy. We went to Gauteng. They held their own public hearings as well. We've met COCTA, Portfolio Committee, on the 10th of June. Bill was also presented to the KZN Speaker on the 11th of June, and we are also going back to KZN actually next week again to present in the legislature. Which was then presented to the Western Cape area on the 18th of June. Now, public hearings were also held in Gauteng, like we said, on the 23rd, 26th, and the 8th of July. Capricorn Municipality in Limpopo requested a briefing. We briefed them on the bill. It was then presented to Salga Bargaining Council. Several times we've done that with them. Presented to Salga and Mpumalanga Province on the 15th of July. And the Portfolio Committee on Local Government in Mpumalanga on the 16th July. And then the House of Traditional Affairs and Khoisan leaders also got a presentation of the bill on the 17th of July. The Portfolio Committee of COCTA, Free State, got a presentation of this bill on the 21st of August 2025, and we presented this bill to Salga National Executive on the 25th of August 2025. And we are still busy with Salga. A few meetings are still ongoing that they have invited us to, and we are still presenting the bill. Presentation to the Limpopo Provincial Portfolio Committee on Public Administration was done on the 2nd of September 2022. KwaZulu-Natal Cabinet received a presentation on this bill on the 3rd of September 2025. And the Northwest Provincial Legislature also received a presentation on the 9th of September 2025. Eastern Cape, 12th September. Northern Cape, 13th September. And Northwest held its public hearing in 4 districts on the 13th of September 2025. And the Free State Forum for Institutions Supporting Democracy received a presentation on this bill on the 22nd of September. So you can see that even in September, we've been to so many meetings and we are here as well. So way forward, we are saying that in the State of the Nation address, the president said that the PSA needs to be resourced. The PSA needs to be empowered and supported. He recognized the role of the PSA. And he said that we need a state that is capable and competent, underpinned by a professional public service. South Africans want a state that treats all people with dignity, humility, and respect. A state with leaders who are prepared to serve our people with complete dedication, and public servants who are ethical, skilled, and properly qualified. This is what the PSA stands for. And we are saying we agree with the president. We are working on that, on building this capable, ethical, and developmental state. PSA is at the initial stage of its learning and relationship building. So we are also pleading for some patience and understanding. We'll still continue with our roadshows even when the bill is passed to make sure that our stakeholders understand and we continue to work together to build a better South Africa. Then we said we all have that responsibility to make every municipality work. This is a call for collective action. Thank you.
Colleagues, I'm going to open the floor first for members of the committee to ask any questions of clarity. Keep in mind that the committee will be deliberating and debating ourselves. So I'm going to limit it entirely to questions of clarity because I think it will also assist perhaps the public. And then I'm going to ask the representatives that want to make public submissions to also ask questions of clarity. So we're not making our submissions yet. We're not debating anything. Only the committee can debate it in any event. So colleagues, questions of clarity. Member van Minnen.
I'm hoping this is a question of clarity. I'd just like a bit of an expansion on the intention to extend into publicly owned entities and the constitutionality of that issue, because that makes me deeply uncomfortable. Thank you.
Any other questions of clarity? I do not see any hands online. Admittedly, I need a bit of assistance because these new glasses are not working. Please proceed, and then we'll get to the beings that want to make submissions.
Okay. In terms of the public entities or public enterprise, we know that all of them, they are part of a government department, even at local government, all of them. They are created to carry the government mandate. It's either if you are doing housing, you establish a public entity to deal with housing, and then they are just to facilitate and make sure that this is, so they all report to a minister, and they are all accountable in terms of either the PFMA or the MFMA. So it's automatic that they are part of the arms of government, and they also want the work from getting public funds. So the PSC will oversee any arm of government, organs of state, and public enterprise where they are using public servants and they are delivering state functions. So this public enterprises, they are delivering state functions, and all of them are accountable. They must all have an annual report. They must always have the strategic plans and all of that. So they are already part of governing, and they didn't even actually object at all to the bill because they know they have ministers. All their ministers have consented because they do need help in terms of the failing nature of our public service. Our chairperson will say Denel used to be so good in the first 10 years of its establishment, and now they are also asking for state funding to support them. Everything is collapsing. And some of the ministers, they don't have proper structures of how to manage their public entities. So with the coming in of the Public Service Commission, we know that the mandate is there all along. It's just resourcing, but we will try to stabilize and close all the gaps where there are weaknesses here and there so that they're able to do things in a more unified form. But looking at the mandate of the PSC, like I have said, we are dealing with public administration and public servants, which is the public service itself. These public entities, they are part of it, and the values apply to them. The PSC can work in terms of their legislation. There is a part here which says to exercise or perform additional powers or functions prescribed by an act of parliament. So what we do is if an institution is a state institution and it's regulated by an act of parliament, by a law that is passed by parliament, then it is a public enterprise. And then we will be having that mandate over there. Thank you.
Member Boyson, keep in mind questions of clarity.
Thank you, Chairperson. We understand that this is for the public. We will have our chance to interrogate this thoroughly. But Chairperson, my question of clarity in general, when you repeal an act, like in this instance, we're repealing the Act of 1997. So in general, when you repeal, it's either there was some hiccups or it didn't serve its full purpose of its intention. Just in this instance, what was the major hiccup probably for the act of that hamstrung the operations?
Okay. It did hamstrung the operations in a few ways. First, the Secretariat. It's a national department, and it's working in terms of national acts and legislation, which is putting our employees in conflict of interest when they are supposed to be having oversight over the public service. So we needed to correct that. Number two, the mandate of the independence and impartiality of the PS is compromised by that. Even the budget and all of that, we had to fight to have a separate vote instead of being passed through a department. So the PSA has to have its own independent budget as a constitutional body. So that was another issue that needed to be addressed. Thirdly, the issue of the commissioner's term of office is not properly fleshed out in terms of what are the requirements, their qualifications, how do you renew? Because the Constitution says that the bill, our PSC Act must deal with that. It's prescribed, and it didn't deal with it. So we needed to correct that. So there are quite a lot of things like that. So that is why we are repealing. Also, the fact that it's also limiting itself to public service, while it failed to recognize that it is dealing with both public service and public administration. And our understanding was that in the past, in the 1993 Act, for example, the Constitution of 1993, the PS was actually a bigger PSC, doing a lot of work, even recruitments and all of that. The PSC has been there for over 100 years. It's just restructuring and changes. So when this one was then passed, some of the functions that the DPS is performing now was part of the PSC's function. So for it to have an oversight, it must have a full oversight and not limit itself. So that is why the bill, the legislation has to be corrected to align to the Constitution properly.
Thank you, Chair. Just to perhaps add on to that, as the Honourable Member can hear, there were quite a few operational and structural challenges with the 1997 legislation, and that led to the Commission deciding that rather than amending the 1997 Act in piecemeal fashion, it would be far more effective to draft a new piece of legislation along the lines as has been described. And in addition to that, we all facing funding challenges as government. The PSC is no different to any other national or provincial department where the fiscus is just not enough, to allow us to fully exhaust our mandate as it should be. And one of the novel introductions in the bill has been for the PSC to now look at a different funding model to, as Advocate Makinde has explained, introduce a provision which will allow us, similarly to the AG, to charge, not for all our services, obviously, but particular investigations. We're seeing more continuously now that we've been approached, whether by executive authorities or other interested parties, to conduct specific investigations into matters within the public administration. And often these matters are not can't fit within the budget. So the Act now allows or will allow the PSC to look at levying particular fees for particular services that we render. We see that as one small way that we can, perhaps supplement the allocation that we get, because it's insufficient at the moment. And if the bill goes through in its current format, obviously it will extend the mandate, and there will be huge ramifications for the operations of the Commission with the extended function. It will have an impact on project costs, operational costs in terms of human resources, etc. And then Honourable Member Van Minnen, maybe just to also supplement what Advocate Makinde said. Section 195 of the Constitution speaks about the constitutional values and principles, and it lists, a host of issues, very important issues, speaking about accountability, efficient, economic, and effective use of resources. And Section 196 then obligates the PSC to be the organ that is responsible for the promotion of those specific constitutional values and principles, not only in the public service, but in local authorities, as well as the Constitution said, public enterprises, your state-owned entities. So our view is 195, if viewed contextually, obligates the Public Service Commission to do the promotion of these constitutional values and principles. And our view is promotion is not talking and having workshops on what those values and principles are. Those values and principles must actually be cascaded into every operational function within a particular department. So even if you're looking at an issue such as a service delivery issue, where there might be operational challenges that we uncover during an inspection, it's evaluating those operational failures in the context of these constitutional values and principles as well. So is a department actually honoring these constitutional values and principles by the way that its operations are actually conducted? Are they effective? Does it pose value for money? And the view from the Commission is that these provisions does allow us to go into that sphere. I accept that there is a different school of thought.
See another question of clarity by Member Van Minnen, and then we're going to be going to members of the public for questions of clarity. Member Van Minnen.
I am constraining myself to questions of clarity, but if I look at definitions of public entities, that includes public universities. So is the proposal that this would also affect the universities across the country?
If one looks at the Constitution, it also speaks about organs of state. And organs of state is a broad definition which would include universities. So the scheme of entities is quite broad, Honourable Member.
Any questions of clarity from the groups that want to make public contributions, or the entities? Any questions of clarity from your side? Right. Then I'm going to proceed. I'm going to be asking you also at the end to comment as well. I'm going to ask the individuals and the organizations that have indicated that they want to make submissions. I'm going to ask you to do so. I'm going to limit you to 15 minutes, right? It doesn't mean that you're under pressure to talk for the full 15 minutes. If you have a shorter submission, but you have 15 minutes. If there is a issue there, then we can deal with it in terms of time if there's a real issue there. But 15 minutes, and I'm going to be starting with, according to how I received them, the group from Veldrif. If you can please just reintroduce yourself, indicate who you're representing, just for the record, and then you can proceed. And it will be the gentleman over there that introduced yourself. Over to you.
Hello everyone, my name is John van der Sky. I represent the people of Veldrif. Organization that I'm in is currently the EFF in Veldrif, Ward 6. If you can just give us a few minutes, you can go on with the other submissions, then we will come back to you.
I do want to point out that this is not a political meeting.
No.
We're looking at a community input.
It's a
I don't
community.
care what your affiliation is, but keep in mind that this is a community-based. We're engaging with communities and with stakeholders at the moment. But I'm happy to give you your break if you need to go and deliberate. So perhaps then, Mr. Root, over to you.
Thank you, Chair. My current position, I'm the Operations and Explosives Manager for a very small security company, Gauntlet Security Solutions. I'm recognized as a bomb mitigation expert globally. I have over 30 years experience working in security, explosive ordnance disposal, and international humanitarian mine action over 13 countries, usually working for the United Nations. My written submission, graciously accepted by the committee, proposes the integration of bomb threat mitigation practices into the Public Service Commission's mandate under Section 1964 of the Constitution. This aligns seamlessly with the PSC's responsibility to uphold Section 195 values of efficiency, accountability, and the provision of adequate resources by addressing a critical and pervasive gap in the public administration safety. Public servants and justice courts, international aviation hubs, administrative offices, and the communities you serve face escalating risks due to inadequate bomb safety protocols, a reality I witnessed firsthand through extensive on-site assessments over the last 8 years. Let's consider just 4 examples of this stark reality. The first one, over the past decades, South Africa has endured thousands of bomb threat incidents annually. That's correct, thousands annually, disrupting lives, work operations, and damage to property. The second one, in 2021, unrest demonstrated this vulnerability when simple petrol bombs used as the weapon of choice in incinerating workplaces in Gauteng and KZN inflicted billions of rands of damage, economic damage, nearly bringing the nation to its knees through a simple petrol bomb. Third one, I personally conducted detailed bomb safety compliance assessments at the Cape Town International Airport, Oral Tambo International Airport, King Shaka International Airport, and each one failed miserably. My last example, this morning, I conducted an informal assessment of this very parliamentary location. I walked around to look at what bomb safety measures I could see visually. I spoke to your security services that were here. I spoke to the various police officials that are stationed here, and I regret to inform you, it fails miserably. The root cause underlying this national failure is the absence, believe it or not, of a national bomb safety standard within the SANS Turn 400 framework, even as of 2025. This leads to, in our opinion, 100% of public officers and employees to adopt a dangerous practice of relying on fire threat protocols to mitigate against a bomb threat incident. A fire threat protocol and a bomb threat protocol are 180 degrees different to each other. This constitutes a national oversight failure with grave consequences, transforming all workplaces into potential kill zones during a bomb threat incident. These deficiencies, which fall under the employer's legal responsibility per the OSH Act, exposes the state to significant legal, civil, and ethical liabilities, particularly with projected civil unrest in the near and immediate future, and even with the G20 later this year. I respectfully propose 3 actionable amendments to the bill. Amendment 1, mandate inclusion. Empower the PSC under Section 1964 to investigate and evaluate bomb threat mitigation practices as a core component of public administration safety, ensuring proactive oversight. Amendment 2, advisory guidance. Direct the PSC to mandate all government departments, such as the Transport Department, who's responsible for airports, the Executive Authority. As I've said, I've gone to the 3 international airports, which is the top 3 in Africa. Each one failed a bomb safety assessment. The Justice and Constitutional Development Department, as an example. I did a presentation about 6 months ago to the Justice Department where I informed them it was my opinion that not one court in South Africa, and I'm including the Constitutional Court, is bomb safety compliant. To all these departments to implement nationally approved bomb safety standards and protocols tailored to the respective sectors and workplaces. Amendment 3, reporting requirements. Require the PSC to include annual reports on bomb safety compliance across all government departments, fostering accountability to Section 19 values. We as an entity, currently the only private security service provider in South Africa, and this is a fact, with specialized bomb mitigation expertise, knowledge, and appropriate IP instruments to address this critical matter. If the Parliament is interested, we offer for free our products and services. The establishment of a draft transformational bomb mitigation policy framework for South Africa. The Western Cape Parliament can take the lead in addressing this big gap of failure in South Africa. A draft national bomb safety standard. You can start it off as a provincial standard, and then it can transcend into a national bomb safety standard and show leadership in this area of failure. A third product we're happy to give is we have established a draft bomb threat safety protocol portfolio for the workplace. There are 34 of these to help guide employers and managers to know how to mitigate against bomb threats. This Parliament can actually show leadership in South Africa, and actually even from an international perspective, because this doesn't exist anywhere in the world. The fourth product is establishment of bomb threat safety standard operating procedures portfolio. There's 39 of them for the private security industry. There's no other single private security company in South Africa that understands bomb mitigation practices. Every single one implements fire threat protocols for all its clients. The Western Cape Parliament can actually show leadership in this area as well. And this is also an innovative product, doesn't exist in the world. The fourth one is the establishment of a framework for the creation of private bomb first responders. This is also a global pioneering initiative. This fills the gap between providing the service on the ground. The big weakness in South Africa at the moment is a misconception of who's responsible for bomb threat safety at the workplace. And this model can address that gap. These resources can not only form the cornerstone of a transformative approach to bomb safety at the workplace, but it can have the following strong outcomes: complete liability protection for the public service, legal compliance to legislation that's not been adhered to by any public office and employee in South Africa, the savings of billions of rands in damages and disrupting businesses and work operations, enhance workplace safety to where it should be. And then the creation, if you implement these products, especially the private bomb first responder, it's the creation of a new business sector, which will lead to the establishment of new businesses and the creation of thousands of new jobs. I urge you to recognize bomb threat mitigation as a priority within the PSC's mandate. This is not merely a safety issue. It's a matter of national security and public trust. I thank you very much.
Thank you, Mr. Rutt. I just want to check Mossel Bay. The Premier's department indicated, from what my understanding, correct me if I'm wrong, you here essentially as observers, you've already done your written submission. The Mossel Bay municipality, do you have a submission that you want to make?
Good morning, Chairperson. From Mossel Bay Municipality, we have submitted our written submission as indicated, and I'm just here to observe. Thank you very much.
Thank you very much. Then the moment of, you have your moment now. It's, I hope that was enough time for you. The community group from Veldrif, your input.
Thank you everyone for receiving us this morning. As the community from Veldrif, we support this Public Service Commission bill, but we have a trust issue because in the public service sector, there's a lot of failures that we face as a community every day, where we have no work, etc., no service delivery, etc. We want the legislation to empower the PSC because it's very important for them to power the PSC, let them come and tackle these issues on the ground by us. But we want to give the PSC a mandate because they must come to the municipalities and do proper oversights, because it seems like there is no accountability for the people at our municipality, what they are doing to us. We are landless, we are jobless, and we must pay high rates for electricity and water. So we feel that we support this bill, although we have trust issues, but we support this bill and we want the legislation to empower the PSC. We saw we saw now that the PSC talked about the political affiliations. That is what we fear the most, because through political affiliation, the PSC might compromise our demands on the ground as a community. And we want to ask the legislation please to empower the PSC more with funding as they indicated, because we think it's important. But the main thing is we want proper oversight at our municipalities and safety from our police service. They are also in the public service sector. Because our police, I think our police is on drugs because they're not protecting us. They are busy arresting the community, specific police. So we want oversight at the police stations, oversight at the municipality. We live in Viadref, we fall under Bergrivier municipality. We have a police station, one police station, Leipelik, that doesn't care about us. So we feel that we support this bill and we want the legislation to empower the PSC so that there can be transparency also in job creations and that stuff, because they only give for political connected people jobs. Political connected people get houses. Political connected people get everything that they want to get, right? But we want an equal society. So we feel that the PSC will accompany us to be an equal society. Thank you.
Just to confirm, are there anyone else from the public present online that wants to make input? Just want to make a double check. Okay, I don't see any hands. I can ask the representatives from the Public Service Commission perhaps to comment on the inputs that were made.
Thank you. Thank you, Chairperson. Perhaps starting with Mr. Witz, to say thank you for the submission and thank you for tabling the issues that you've noted. I've recorded 4 specific issues that you are tabling as possible amendments. My comments on that, Chair, is that if one looks at the current version of the bill, it's drafted in a way that gives impetus to what the constitutional provisions state with regards to what our powers and functions are. It would be very challenging and problematic, in my view, if one drills down into those specific powers and functions and now refers to individual items, for example, bomb safety and implementation of specific programs. So from where I'm sitting, I think it would be a challenge considering those amendments and expanding it to the individualistic nature that it is. My comment would be that the work that the Commission would do is based on what the law provides, and whether there are individual issues that fall within that framework, the PSC will then exercise its mandate. I think that's the most suitable way that I could frame that. In addition to that, some of the issues mentioned, Chair, I would hazard a response to say that it might be outside of the domain of the Commission, because we're looking at possible issues that apply to state security and other national departments that are responsible for safety and security. If there is a challenge in terms of engagement and tabling specific issues for consideration and discussion at the department, I would say to Mr. Teruot that the Commission, as part of its functioning, will be able to engage with the industry or the sector on those specific issues. But as far as the bill is concerned, my comments are made with regards to that. Then for the Veldrif community, thank you very much. We note your support for the bill. The only issue that I will specifically address, Chair, is the presenter mentioned the issue of political affiliation. And as Advocate Makinde indicated, the bill now provides a provision that says that no sitting member of parliament, member of a council or political office bearer will be able to apply for the position of commissioner. And that particular provision actually stemmed from debate in the Portfolio Committee in the National Assembly, where the members themselves tabled that particular provision and suggested the 2-year cooling off period, specifically with the intention of safeguarding the independence of the Public Service Commission and to avoid any adverse inferences that you could assume if an individual who might have political affiliations now suddenly moves from one seat and moves into the position of commissioner. So the commission takes the issue of independence extremely seriously, and the bill is now drafted in such a way to ensure that there is a clear distinction between the role of a commissioner and the time periods that are involved when a possible politically associated individual moves from that sphere and considers a role as a possible commissioner. So I think the bill has gone some way to entrench that independence. And then just currently, the commission, all of us, we go through a vigorous process within the legislature and within the National Assembly, where we compete for a position. We're not political appointees. We compete for a position in front of you. You assess our performance and you make a recommendation. It's adopted by the legislature and then endorsed by the Premier, and final appointment is made by the President. And my response would be, although the Constitution envisages a political process for the appointment, the ultimate appointments are not based on political allegiances. It's based on the professionalism, skills, and expertise that a particular individual holds and is considered appropriate for appointment as a commissioner. Thank you, Chairperson. I'm not sure if Advocate Makinde wanted to add one or two things.
Let's proceed.
Just a little bit. The issue of the bomb and the safety, it's a matter that is receiving national attention at the moment. And there are policy development that the state security services are looking at in that area. Because now that we're, like he mentioned, the G20, now that we're having international guests, even some gift items, you need now to send them for screening before you can accept them. You don't know whether there is something inside it or a chip or what. But that is understood. But what the PSC does not do is that we don't do operational activities. We're an oversight body. So when we recognize that there is the state security and there are other institutions that are dealing with that, all we can do is to get into that from an oversight perspective. And the bill as it stands now can do that. Does not need an amendment to do that, because that will just looking at the state administration, whether there's effectiveness, whether there's efficiency, whether they are doing their work. We look at the policy perspective. As and when that is identified as an area of concern, there can be such little bit of intervention, and there could be something to say, state security of buildings, maybe public works, and the people that they put there and all of that in terms of the parliament precincts, all those airports and things, they could look at that, but it would not be necessary to include that in our bill, because that is not our core mandate. It is just something that we do general oversight as and when necessary, especially because you have the state security services and you have the SAP, you have bodies that are specifically meant to do that, that it forms part of their own operational legislation. And that is that. The other report in terms of the service delivery, commissioner has already dealt with it. We will look at that from time to time. It's just, it's something to be noted. The PSC is independent and impartial. Our aim is to assist and make sure that things are going on properly. And the reason why we are being told to implement our full mandate is because of the challenges that the country is currently facing. And we hope that our impact will be felt when we come in. Thank you.
Thank you very much. Then, colleagues, we seem to have exhausted the inputs from members of the public and the groupings from the public. I'm going to propose, or I'm going to ask whether there is a resolution that we conclude the public hearing part of this particular committee meeting. I don't see anyone else. So, yes, can I just point out that you're welcome to make a counterpoint. I'll allow that. Your submission is actually to the committee. It's not to the Public Service Commission. So we're not necessarily persuaded by them. We're not necessarily persuaded by you. So, but please make, I notice you wanted to make a counterpoint. But colleagues, after that, if I can ask one of our members then to either propose that we wait until 12:30 or propose that we conclude the public hearing part. but colleagues, I'll get to that after Mr. Rutte has made I think you seemed like you have had a fire in your belly, no pun intended, to make a counterpoint there.
Thank you, Chair. As a way to try and explain the problem we have in South Africa with regards to who's responsible, the big misconception, who's responsible for bomb mitigation? Is it government? Is it the police? Is it etc.? It's not government, it's the employer. As an example, let's say a bomb threat incident where it's a confirmed bomb comprises of 8 phases. Of those 8 phases, it's only one phase, phase 6, that's the responsibility of the police. All other 7 phases is the responsibility of the employer. You talk about G20, the G20 government only get involved in tier 2 level provisional services, even with regards to bomb. The police and bomb squad that comes in, they only provide tier 2 level services. Tier 1 is completely the employers on the ground. The third one to come to is, for example, the National Bomb Safety Standard. It is 2025. I think we're the only country in the world that does not have a bomb safety standard. It's not the police's responsibility of putting the bomb safety standard together. It's the people on the ground and the employees that are the primary stakeholders. The police only play a certain role. Thank you very much.
Represent, colleagues, do we wait for the allocated time, or have we exhausted the public hearings? I'm looking for a proposal from the floor. Member Van Minen.
I propose that if we have dealt with everybody's questions and inputs, that we can actually adjourn early. So yes, I propose that.
Do I have a seconder?
Second the proposal, Chair.
Okay. Colleagues, what I will propose is that we adjourn also now for a bit of a break. I think it is an opportunity to also interact. There is coffee outside. I don't want wasteful expenditure. So, and then afterwards we'll come back to deal with the minutes of our previous meeting, and in case there's any resolutions we want to take in this particular committee meeting. So we're adjourning the public hearing part of the meeting now as per the resolution. We're going to take a break. Let's make it 15 minutes. I think it's also important for us to interact with members of the public and the commissioner. And then afterwards, we'll come back to just conclude the rest of our business. Thank you very much. colleagues, keep in mind it was a public hearing, but are there any resolutions or recommendations that springs to mind? Keep in mind we will be deliberating as a committee on our own as well. Member Boyson?
Thank you, Chairperson. Chairperson, I would just recommend that we as a committee, that we take note of the inputs that were given, and deliberations will then follow after that when it's time for that.
Just want to check with, I see Member Stevens is online. And Mr. Heron, or Member Heron, any proposed resolutions or recommendations from your side?
And none from mine, Chair.
Okay, so I don't see any hands there. Member Stevens?
Thank you, Chair. I don't know whether they want to take it as a recommendation, but I just wanted to know on the bill, on the whistleblowers, does the bill contain provision for protecting whistleblowers who expose corruption or maladministration within the public service? If not, how does the government intend to safeguard these individuals given the high risk they face? Thank you, Chair.
Member Stevens, from my knowledge, whistleblower legislation, that would be part of the Protected Disclosures Act. But what I think we should do is maybe that question we should record as the resolution should be that we just get clarity how the Protected Disclosures Act whistleblower status, how it works in terms of submitting complaints to the Public Service Commission. Does that capture your input, Member Stevens?
Yes, thank you, Chair.
Okay. Then I saw Member Sayed.
Oh, thank you, Chair. I mean, obviously for the hearing, I was logged in but just I picked up a small part. Maybe it's not related necessarily to the bill, but perhaps maybe to be referred to another committee. The bomb issues, the security issues that was raised. I think it was a Mr. Root who raised this. Maybe you want to refer that to Parliamentary Oversight Committee, so that they can probably maybe look into that. He can maybe do a presentation, or even also the Mobility Committee, and then possibly bring in the National Department of Transport, give him that type of audience maybe, because yeah, around the airports. Thank you.
Colleagues, any other proposed recommendations? I don't see any other hands. I think we all agree on the recommendations or the inputs that were made. Right, colleagues, then the next item on the agenda is the minutes, so that we do some minutes that we need to approve. There was just pointed out to me that in the response from the Public Service Commission that they indicated to Mr. Rutte that they will assist him to find the right platform as well. Now, I still think your recommendation, I think, is very valid. We must get that risk that it was identified. I think certainly in the was taken up in the Western Cape government. So there's Member Sayed's resolution. Can I suggest we formulate that just as a follow-up, that he's been assisted to the correct channel, that we just, as a committee, also follow up? Right, colleagues, so I think that exhausts the recommendations and the resolutions. if we can go to the minutes. But colleagues, there you can see the minutes. Let's just check whether your presence has been recorded correctly or lack thereof. Colleagues, can I have a proposer? Member Boyson?
Chairperson, I propose adoption of the minutes.
I have a seconder. See Member van Minnen.
Second.
Right, and I don't see any other hands. So, colleagues, the minutes have been adopted. And then just as the last check, anything else? I just want to double check with the procedural officer, anything else that we need to deal with? Colleagues, thank you very much for your presence, online and physical. Much appreciated. I will see you at the next committee meeting. The meeting's been concluded.
Thank you, Chair.
Thank you,
Thank you,
Chair.
colleagues.
Thank you.